What gives me the right to ask a doctor hypothetical questions when I question him during a pretrial question and answer session known as a deposition in a medical malpractice case where you have sued your doctor? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you sued your doctor claiming that he was careless and that his carelessness caused you harm and injury. During the course of your lawsuit, the doctor whom you have sued has to appear for questioning, known as a deposition. This ordinarily in pre-COVID times takes place in the doctor's attorney's office in his conference room. During COVID times, it typically takes place on a Zoom video call. The doctor will be on the call, the doctor's attorney will be on the call, I will be on the call, and there will be a court stenographer on the call to record all of my questions and all of the answers that the doctor gives. Now, you should understand something. This deposition is very important. It's important because the answers that the doctor gives in response to my questions represent his sworn testimony that takes place before we ever get to court, before we ever get to trial. So now it carries the same exact weight as if the doctor is testifying in court in front of a judge and in front of a jury. During the course of my questioning, I actually have an opportunity to ask the doctor hypothetical questions. Now, why is that? I'll tell you why. In New York, the doctor whom you have sued is considered to be a medical expert. Now, whether he is or isn't is a question of fact for the jury to determine. But the law considers him, because he has advanced knowledge and training, because he has gone to medical school and done a residency, because he has experience in his particular field of medicine, the law considers him to be an expert in his field. My goal is to try and disprove that theory, to try and show that he's really not an expert, that he doesn't have a good handle and a good knowledge of medicine, among other things. So now, during this questioning, this pretrial question and answer process known as a deposition, in New York, I am permitted to ask the doctor hypothetical questions. So I am asking a leading question. Doctor, I want you to assume that Mrs. Jones came to see you on January 1st. We can agree on that, correct? Yes. Assuming that to be true, now I also want you to assume that on that very first visit, Mrs. Jones told you she had a complaint of a lump in her left breast, okay? So you're assuming that to be true. Would you agree, doctor, that good medical practice requires you to take a detailed, thorough history? Yes, it would. Would you agree that good medical practice requires that you go ahead and document that medical history? Yes, it would. Would you agree, doctor, that following taking a detailed, thorough history and documenting it, it's critically important for you to perform a physical examination? Yes, I would. And it's important for you to document the fact that you performed the physical examination. Isn't that true? Yes. So what am I doing in this example? Right now, I'm just asking basic leading questions. I haven't gotten any hypothetical questions yet. I'm setting the stage. Why? Because I want the doctor to be able to answer questions based upon our version of the facts. It's clear from the very beginning of this case that our version of the facts differs from the doctor's version of the facts. The doctor has a different opinion, a different memory, a different recollection of this particular case and of the facts in this case. So now, in order for me to get the doctor to answer medical expert questions about our version of the facts, I have to ask the doctor a hypothetical question. Because if I were to say, doctor, isn't it true that Mrs. Jones on her first visit came in complaining of a lump in her left breast? He's going to look at his notes from a couple of years earlier and see that there's no complaint whatsoever that he documented about Mrs. Jones making a complaint of pain or a lump in her breast. So he's going to say, no, the patient did not make a complaint of a lump in her breast. And that's going to start a snowball effect about what he did and why. Okay, so now I want the doctor to assume for a moment that on the very first visit, Mrs. Jones did in fact, as she has testified in her pretrial deposition. Of course I told the doctor, that's the exact reason why I went to him. Because I had a lump in my breast, I felt it when I examined myself, and as a result, that's why I went to his office, to get checked out. So now I have the ability to ask the doctor that if our version of the facts are true, he would have done things differently. Doctor, I want you to assume that on the very first visit that Mrs. Jones came to see you, she did in fact complain of a lump in her left breast. Would you agree in that instance, good medical practice requires that you take a detailed history about that particular lump? How long it's been there? When did she notice it? Did she notice if it was changed? What else did she notice or observe about that particular lump? Did it go away during certain times of the month? Did it recur? How long has it been there? And questions like that. Now, why is that important? It's important because my client has testified during her pretrial deposition that that was the precise reason why she went to his office. The doctor denies that. So now the doctor will have to tell me, yes, if the patient came in complaining of a lump in her left breast, good medical practice requires that I take a detailed, thorough history to determine whether or not there's any history of breast cancer. It also requires that I do a detailed examination of the patient as well as an examination of her breast. And doctor, would you agree that when examining her breast, it's critically important for you to examine it while she's sitting up as well as while she's lying down, correct? Yes. And would you agree that based upon your physical examination findings, you would then determine whether or not to send her out to a specialist, to a breast surgeon for further evaluation? Isn't that correct? Yes. And if you suspected that there was a lump present or you felt that a lump was present, good medical practice required that you send this patient out to a specialist, to a breast surgeon, to get evaluated. Isn't that true? Yes. And would you agree, doctor, that failing to send this patient out to a breast specialist, a breast surgeon, under these circumstances would be a violation, a departure from the standard of care? Now, the doctor's going to argue with me, his attorney's going to argue with me, but the law requires that the doctor answer that question. Why? Because he is considered a medical expert. And although the doctor disputes those particular facts that I've asked him to assume, he is still required to answer those questions. Why? Because the law considers him to be a medical expert, and because we have a sufficient foundation to establish and to show that there is a good faith basis to ask this question. Because my client has already told us, she's told the attorneys involved in this case during her pretrial questioning, that that was the specific reason, that was her specific complaint that she made to the doctor on this very first visit. So doctor, assuming those facts to be true, you would agree that good medical practice requires that you do a detailed history of her breast and breast history, correct? Yes. As well as doing a detailed physical examination of this patient. Isn't that true? Yes, it is. And failing to do those things would be a departure and a violation from the standard of care. Isn't that correct? Yes, it is. Now, doctor, I want you to assume that the patient indicated to you that this particular breast lump recurred a couple of times that month, and now it changed shape. And in addition, there was fluid leaking from it. Would you agree that that information would be important for you as the physician to know and to understand? Yes, it would. Tell me why. Now I'm asking an open-ended question. Tell me why it would be important for you to understand that. And now the doctor's going to give me the reasoning, the medical reasoning why this information is important. Tell me the significance of what those facts would mean to you. And now the doctor is again going to explain what the significance of those findings are, indicating most likely that they are highly suggestive of an abnormal finding that requires immediate follow-up with a breast specialist. Doctor, would you agree at that point, as far as formulating your plan of treatment, you have to come up with what you believe to be a differential diagnosis? Yes, I would. And a differential diagnosis is nothing more than a list of the most likely causes of the patient's ongoing complaints and problems. Would you agree with that? Yes, I would. And as part of your differential diagnosis, doctor, you list pretty much in order of most likely down to least likely. Isn't that true? Yes. And would you agree, doctor, that good medical practice requires, in order for you to attempt to rule in or rule out any one of those conditions, starting with the most likely, it's important for you to either do various tests, diagnostic and laboratory tests, correct? Yes. Or send the patient out to a specialist so that now they can go ahead and further evaluate this patient's problem. Isn't that true? Yes, it is. And what am I doing? I'm getting the doctor to go ahead and to recognize that there are specific sets of facts that my client has testified about. I want him to accept for the moment that these are true. In that instance, I now have to take him through step by step to understand what he would do if those things actually happen. Now, why is this all important? I'll tell you why. Because there are clear, different, opposing sets or versions of the facts here. When this case gets to trial, the jury will have to evaluate who is more believable. The jury will have to decide who is more credible, Who is more likely right than wrong, than what we are claiming is true? Is the injured patient, the injured victim, more believable than the doctor? Now, why is this all important? It's important because if the jury believes our version of the facts, as opposed to the version put out by the doctor, then guess what? Now I can go back to the pretrial testimony where I talked to the doctor about these hypothetical questions, where I asked him specifically to assume that our version of the facts are true. Now I can go ahead and show to the jury, hey, ladies and gentlemen, if you believe Mrs. Jones's version of the events and the facts that occurred here, well, take a look at the doctor's pretrial testimony. He's already indicated that yes, if she came in complaining of the following breast lump, it's critically important to go ahead and do X, Y, and Z. It's definitely important and clearly good medical practice to do a history and a physical. And it's also critically important to go ahead and send the patient out to a breast surgeon. And the testimony and the evidence has shown, ladies and gentlemen, that our version of the facts is more likely true than not true. And in that instance, now the jury can turn to the doctor's testimony that he gave during his pretrial questioning and clearly say, hey, listen, the doctor has admitted that if he did not do these things and these facts are true, that yes, it's a departure from the standard of care. And yes, and now go through step by step. So that's why it's critically important that I am permitted to go ahead and ask the doctor these hypothetical questions because the law considers him to be a medical expert in these scenarios. Why do I share this with you? I share it with you not because you wanted to see the beautiful scenery where I'm walking around the neighborhood, but because you likely have questions or concerns about your own matter. If your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.